36-30 Falcons win.
That's Fox's Jared Max. It's down to the final 8 teams in the baseball playoffs. The New York Mets advanced, eliminating the Brewers in Milwaukee with a 4-2 comeback win powered by Pete Alonso's 9th-inning home run. I'm Dave Anthony, and this is Fox News.
Lawrence County depends on WDXE News, on the air since 1951. This is The Legend. 105.3, 95.3, WDXE.
And we've made it to another Friday, and our friend Stan Pierchoski is in the house. How are you, my buddy?
Good morning, Jeff. Good morning.
Good morning to you. Good morning to you. It is Friday already. Can you believe it?
It is.
Are your headphones not up?
No, they're a little bit hot.
How about that?
This one.
Is that better?
That just about turned it off, so turn it back on.
There we go.
Okay, that'll
There we
work.
go. All right.
No, I'm good. How about you?
Very good. Very good. Those buttons get messed with, and different people come and go.
I got you. No problem. We can fix it.
How are you?
I'm good. These cool mornings are not hard to take.
Yeah, I like it myself. I do too.
I think our 2 weeks of fall has finally arrived, right?
Yes, indeed.
Yeah.
All right. I'm making sure that we're on like we're supposed to be on, and we are. We're good.
We're good.
We're good. Hey, I need to correct something. I made a mistake a few minutes ago with a Bible trivia winner.
You know what? I made a mistake once before.
You did?
Yeah, it was back in the second grade. I thought I was wrong, but I wasn't.
Yeah, there you go. See, there you go. My Bible trivia winner today was actually Faye Pig, and we'll fix that, okay?
Okay.
And I don't know if that's a call for us.
Well, you can go ahead and take it because we hadn't got started
We're just trying
yet.
to get started. Hey, good morning. How are you? Hey, you're on WDXE with us.
Yes, I'd like to have you announce that we're having a yard sale in the New Prospect area,
Yes.
180 Wesley Chapel Road.
All right.
Men, women, kids' clothes, baby clothes,
All right.
lots of clothes, brand new with tags hanging on them,
Well, all right,
all
honey.
kinds of knickknacks.
All right. Well, thank you. I appreciate it.
All right, thank you.
Very good. Sorry about that.
That's all right.
We have a trading post, of course, earlier and all that, but we got a lot of yard sales today. There were lots of
Well, they got the weather for it. So.
Got the weather for it.
All right. So we want to talk about the seminar coming up, which
Oh, that's right.
about a month out. It's November the 2nd. It's going to be up at Franklin. We call it Will's Trust in the Nursing Home. And November the 2nd is a Saturday. So we do Saturday seminars at 10 o'clock in the morning. So it's at a place called Suite 501. The physical address is 416 Mary Lindsay Polk Drive up in Franklin. So if you want to get RSVP'd for that, you just call my office, 931-363-7222 at Pierchoski Estate Law, Pierchoski Elder Law, and get on the RSVP list. And just let us know what the head count's going to be, and so we have plenty of chairs. And I'll bring that up again at the end of the hour. So,
Very good. Very good.
but yeah,
Looking forward to that.
well, good. Are you coming?
Well, I'm always looking forward to your visits and your seminars.
Yeah, it might be a little repetitive for you. So,
Well, I have learned a lot. I must say.
no, I agree.
I've learned a lot. And,
So we also want to remind folks it's a call-in show. You can call in and ask questions.
we do invite your call in. Yes.
And there's a call-in number, which is 931-766-9393, 766-9393. Pretty easy to remember.
Yeah.
Call in if you got a question or if you got an experience to share or, just anything.
Absolutely.
Anything.
Absolutely. We certainly encourage that. It makes it interesting and fun to hear people's experiences and give us something to kind of dig into.
Right. I mean, some people, when people peruse the internet or search for things,
Right.
They get exposed to a lot, and it's not all right. I mean,
That's true.
In the old days, before the internet, I remember people would take the position: if it's in print, it's got to be true.
Yes.
If it's in a newspaper, if it's in a book, it's got to be gospel. I mean, and even then, that wasn't true. But especially on the internet, there's a lot of misinformation, or at least information that's not entirely correct, or it's coming from not really a authorized source, but somebody just voicing an opinion maybe without saying that this is just my opinion. It may appear to be fact, but you need to check all that stuff out. And so I get a lot of people asking me questions about certain things that said, I've heard about this. Is that something that can be done?
Sure.
Something I heard about recently was if you're concerned about long-term care, is it worth getting divorced just before that happens?
Oh, wow.
And there is some strategy out there for that. I'm not a big fan of it. I have analyzed it, and I don't care for it, and I don't recommend it. But there is something out there. I think it's got a lot of backlash to it, or could have a lot of pushback. And
Yeah.
so I don't really recommend it, but stuff like that. I mean, I looked
amazing.
and there's a lot written on it, and it's written with a slant that all what they consider to be the advantages, but they don't dive deep enough. For example, I'm not going to talk about that today, but just for example,
Yeah.
the article I was reading said, if you can get divorced, when you get divorced, you have what is called an MDA, a marital dissolution agreement, which is an agreement basically how you're going to split the property, stuff like that.
Yeah.
We're going to keep kids out of the picture because usually if people are doing this for long-term care, they don't have kids.
Right.
I mean, they don't have minor kids to deal with,
Sure.
like a divorce. And so it'll say, technically, we're not a community property state, but it's still an equitable distribution, meaning pretty much 50-50, especially for long-term marriages, right?
Yeah. Yeah.
And so what they do is they have an inequitable marital dissolution agreement, which is like heavily sided toward the community spouse, the spouse who's not in care. So the spouse that's in care kind of getting the short end of the stick on this agreement. Now, when you have this agreement, more often than not, if not always, the court would not necessarily object to it because it's an agreement. You can resolve anything by agreement.
Yeah.
And the court usually brings the parties in and say, I have this marital dissolution agreement. Husband, do you agree with this? He says, yes. Wife, do you agree with this? Yes. And they both sign it. So the court feels like, why interfere if the parties know more about their own circumstances than the court and everybody's agreeing to this, then that's okay. That's usually the way agreements go, and that's they're very handy in resolving a dispute resolution and cases. But when it's lopsided like that, now the problem comes then when they apply, they put down what their assets are, and they're like now a single person. They've only got these assets. If somebody like TennCare, the long-term care industry, can get wind of that, and they usually do because it's public record,
Yeah.
and they'll find you were divorced,
Yeah.
they will treat that as asset. They'll look at that and say, well, you were entitled to take half of these assets, or roughly half, right?
Right.
Or an equitable distribution, and you chose by agreement not to, okay?
Yeah.
And that choice by agreement not to is going to be a divestment. It's just like you gave it away. You were entitled to it, and you gave it up.
Right.
So it doesn't. Now, will they always catch that? Maybe not, because they're TennCare and a government organization, and efficiency is not the greatest.
Yeah.
But I would never bank on that
Yeah.
concept. So
Yeah.
it's not I'm not a fan of it. If people want to do that, I tell them you can probably find somebody that can do that for you, but I'm not gonna because it's
It
just
sounds to me like they're trying to outslick the system.
it is. That's exactly what it is.
Yeah.
And you're banking on the fact that they won't catch it.
Yeah.
Because if they do catch it, they will impose the penalty
Yeah.
for it. So, that's just one aspect of it I didn't like. There's a couple others. But,
Yeah.
but you, when you search the internet, you find a lot of misinformation.
Yeah.
Now, something I want to talk about today, I don't know if it's necessarily as a result of misinformation on the internet, but it's a misunderstood concept. And a lot of people are concerned about it right now because of, this election coming up in a month. Depending on how it goes, this concept might come into fruition. Now this is not a political discussion, so don't call up
Yeah.
and give me and yell at me for this. But I'm going to talk about capital gains taxes.
Oh, wow. Okay.
Or capital gain and capital gain taxes. Now, I'm not, right off the front, here's my disclaimer. I'm not a tax attorney, so we're not going to do this deep dive. But I do understand how it works with respect to estate planning and what we do for asset protection.
Okay.
And putting property into a trust. So let me just start from scratch. And if you know this, some of this fundamental, bear with me. If you don't, it'll help you understand. But people ask it a lot. If people ask it a lot, it tells me it's something probably ought to be talked about.
Sure.
So, let's just say, I'll use you, Jeff. You have a house, and you and your wife, Teresa, bought this house. I don't know. Let's say you bought it 20 years ago.
Yeah.
20 years ago, you paid $100,000 for it.
Right.
I'm going to use nice round numbers on the radio because it's easy. You can't see my whiteboard. So we'll use easy numbers. So, you're sitting here with this house that you paid $100,000 for 20 years ago. That $100,000 is what is called your cost basis, okay? Because that's what you paid for. Now, if you and Teresa decided, you know what, this now in 2022 when they did the last tax appraisal, this house is worth more. And of course, the tax appraisal is usually lower than what you can sell it for. So you're in real estate, and so you look into the market and you say, hey, we could sell our house for $200,000, twice as much. And so if you decide to do that, and you guys sell it, you sell it now, you get $200 for it, you will have a $100,000 capital gain. So the gain is what's over the tax basis.
Yes.
Okay. Now, if you realize that gain, then realizing the gain means you keep the money, and after 180 days, you still just have the money. You didn't do anything with the money.
Right.
you now have now realized the capital gain, and now the capital gain tax is due on the gain, which is $100,000. Yes. And it's pretty steep tax. It's like 28.8%, and can be as high as 40, but typically you see it about 28.8. Now, another thing that goes on is, let's say you decide to give the property away during life. Okay, this is what some people do when they maybe think long-term care is in the relatively near future. They say, well, you know what? Let's deed it to our child. Inter vivos gift, meaning during life. Let's just send it to them, $10, love and affection. So they're giving it to them, but they're not getting anything for it, okay?
Right.
So you gift it to the child. What you've done is now the child owns it, but the child's cost basis is the same as your cost basis, $100,000.
Yeah.
And the reason is because when you gift it away, there's no bargain for sale or exchange and no way to calculate a cost basis for the new owner other than to transfer the existing one to them. So if you give it to a child on Monday and the child turns around and sells it on Tuesday, they have right off the bat, $100,000 capital gain liability.
Yes.
You have handed them that. Okay, so that's a disadvantage of giving during inter-life or inter vivos during life gifts. So now, if you give it to them after death, like you put in your trust and you say, I leave, same result, I leave my home to this child, okay,
yes.
is the distribution. Now what happens is there's something called a step-up in basis. And when the child inherits this piece of property, their cost basis is stepped up and is now, the cost basis for them is the fair market value the day of death. So if you guys pass away and it's worth $200,000, the child's cost basis is now $200,000.
Yeah.
So if they turn around and sell it the very next day, no capital gain.
Yeah.
Yeah. But if they hold it for 20 years and it goes to 400, well, they have their own capital gain, but it started from the stepped-up number.
Yes.
So preserving this step-up in basis is a very big advantage to your heirs. I mean, it's a very valuable thing. Sometimes we pass property during life because we just have to, but usually it's farmland that's been in the family for years, and so we can cure that by that person we gifted to during life just leaving it to somebody later on, and that'll cure any capital gain, any cost basis that came to them.
Right.
Okay. So you don't. I get people to say I'm worried about selling this house because it's going to be a capital gain, but you can there's ways to there's ways to defer the capital gain. So let's go back to you selling the house. You and Teresa sell it during life.
Okay.
And you get $200,000 for it.
Okay.
If you turn around and buy another piece of property that's that value or more,
right,
you can kick the can down the road on the capital gain and the reason is they're not going to consider that realizing it. To realize it, you got to keep the cash. After 180 days, it's considered realized, and now the tax is due. But you can, and they do they call it a 1031 exchange, right? And when you do that, the law is designed to encourage home ownership. So young couples get out to buy their first house. They have a child or two, and their job, advances a little bit. Your status in life improves. It's time to sell the house, buy something bigger, maybe something nicer, and that probably happens 2 or 3 times or more on the average person throughout their working career. And so it's to encourage that, not hammer you every time you sell something simply because the market went up. And if that was the case, the capital gains that went on during 2022 when land was it's like somebody rang a bell and, just whatever it's listed for, offer $50,000 more. It was just ridiculous.
Right.
And the people that found that out the hard way were people that said, wow, this is worth so much more than I thought it was. I'm going to sell it. So they do. But then when they turn around and try to buy something to replace it, now they got to pay so much more for it because everybody's doing that. But the values went sky high, so there was a lot of capital gains issues. But there's no tax. There's rarely a tax until you just sell it and keep the money. Now, the reason people are bringing this up a lot, I talk about that a lot either at seminars or with folks who ask. But the reason I find people bringing it up a lot, there's a promise, a campaign promise that they're going to tax unrealized capital gains. Now, I've heard some. I haven't seen. I mean, when you hear these promises, you don't know you don't know the words behind it. You don't know the plan. You don't see it written down. You just hear what they say they're going to do.
Yes.
So I've heard, and I'm going to say this. I have no clue if this is based in fact or not. I heard that the value's got to be a certain base amount. I heard, but only if the value's worth $100 million or more. Now, I find it hard to believe that you would impose a tax and place it in a position where it's rarely going to be even imposed, right?
Yeah.
But let's just say they impose it, okay?
Yeah.
I can't think of a single most devastating act than that, because now you're paying a tax on something simply because it's changing in value every year.
Yeah.
It's going to be tens and tens of thousands of dollars to anybody that owns property.
Yes.
And I have clients that own 5, 6, 10, I think my record is somebody came in and we had to do like 37 deeds because they had a lot of rental properties.
Sure.
I mean, can you imagine? I think you'd wear out an accountant. And you certainly wear out your bank account, because if you have to pay, and then there's the concept: what if the value goes down? Do you get any money back? And probably not, but we don't know.
Yeah.
But you have to have a firm understanding of capital gains, because it's not just the capital gains is just not out there in a vacuum. It has to, before you pay any tax, you have to realize the gain, and realizing means you sell it, you get the extra $100,000 and you just pocket it.
Right.
Put it in your bank account and keep it. If you use it for something over 6 months and roll it into something else, no tax.
Yeah.
It's an incentive. But so I don't know how if things go. I think that's going to be a real problem. But
Yeah, I've heard some rumors about that myself.
I mean, the first revolution was over taxes, and that was like 1% or 2%. I mean, this has got a lot of teeth to it.
But being taxed on unrealized gain, they were talking about even on the stock market.
Oh yeah, I mean, unrealized gain is on property.
On property,
not necessarily real estate.
Yeah.
Stocks, like you said, bonds, things that you own that change in value. I mean, first of all, it's going to be a accounting nightmare.
I would say so,
because it's a moving target. When do you pay this? Do you pay it when you do your April 15th tax return, and the value of that day might be something different? Or if you have a period of time to do it, you can kind of maybe wait, maybe you can hit it at a low. Now, real estate doesn't, how do you determine? I guess then, I was watching something, I won't name names, but somebody mentioned if this happens, you need to run out and open an appraisal service because they're the only ones going to be making money. And so, if you're going to do it on this real estate, how do we determine what it's worth to calculate the gain? And, normally now, if you're in court and the court orders a sale of something for some reason, part of a controversy, they'll usually say, okay, we need to get, 2, maybe 3 appraisals, and we'll go with the average or something like that. Because, if you get 3 appraisals, they're all going to be different, right?
That's correct.
Not necessarily wildly different, but you're going to have a high, low, and middle.
Sure.
And so, but it's supposed to be representative of the market, and you'd say, okay, we'll take the average. And so we have to do this for every single house, every single year. I mean, what's the standard? Or are they just going to do it for us and come out with a chart and say, well, it goes up, it's 20% every year? I don't know. I haven't got a clue. But the reason I bring it up is it sparked a lot of calls and questions to me. Some I don't have the answer to. I said, we're not going to know until we see it. But if it's the way they talk, and when you hear them talk about it, they don't give you very much. Where's the beef? I can't, there's nothing to put your teeth into is exactly how it's going to look.
Right.
Now, if it comes out and says it's only for properties over $100 million in worth, I'd venture to say 99.9% of us here in southern middle Tennessee don't have to worry about it.
No.
But then again, there's going to be 0.01 or 1% that does. And if the purpose of the tax is to raise revenue, there won't be much.
Yes.
I find it hard to believe because they say that to tone it down.
Yeah.
But then the power to tax is the power to destroy. If you can tax, then you have if you tax $1, you have the authority to tax $1,000.
Yes.
The amount of tax is not the constitutional issue.
Or if you tax $1 million, you have the authority to tax $10.
That's right. If you have the authority to tax, that's all the courts would ever rule on. The amount has nothing to do with the legitimacy of the tax. It's just it's kind of like the old story of the boy and the frog.
Yeah. Well, it's kind of like you said earlier. I mean, this is a political climate, and these ideas are being thrown out, and this, that, and the other. But it is concerning to think that they may consider taxing unrealized gain.
They do. And, because of the election, I just seem to get a flood of business coming in. People feel a need to do it beforehand. So kind of saw a little bit of that last time around, too.
It happens.
I'm trying to remember, but I'm not sure what the thought process is there. Just there's other things people are trying to do.
The election year always affects the business climate.
It does.
Period.
It does because, so Anyway, like I said, that wouldn't be a political discussion. It was just to bring up the fact that a lot of people have concerns about that, and I thought I'd shed as much light on it.
That's
I
very
can
interesting.
shed light on how capital gains tax work now.
Yes.
I'm not quite sure how they'll work in the future, depending on how things go, but we will know at some time.
Yeah.
Now,
Yeah.
whether that's good or bad, no promises. But at least we'll know it.
Yeah.
So
In the beginning there, you mentioned, the misconceptions. Is there something that's fairly common? I mean, you've already mentioned a couple, but is there anything that stands out as people's misconceptions concerning trust or those kind of things?
there are. Some people feel like a trust, or they get this information to feel, trust is only for rich people,
Yeah.
or something like that. It wouldn't apply to the average person.
Yeah.
And I mean, that is the opposite is true, in my opinion. And I don't say that because we do it. I mean, we do it because it fits everybody. If you have a trust, you have control over where property goes, and you can make sure that it goes that way.
Yes.
So if you don't have a trust, and if you're not rich, right, then it's a little more important that the property go where it's supposed to go.
Yeah.
Right, and not be consumed or pilfered or something like that.
Right.
When you do hear about rich people with movie stars that have trusts, and they do. Celebrities, I'll say, not movie stars. Celebrities have trusts.
Yeah.
And sometimes they'll get into a court battle or
Yep.
something.
Yep.
And it's $100 million estate.
Yeah.
And they'll say, it's so expensive. They lost $30 million in this battle.
Yeah.
But see, they still have $70 million to spread around.
Yeah.
If it's you or me, we don't lose. We still have the same, let's say, third loss of cost of everything.
Right.
But now it's a greater impact, right? 'Cause
Yeah.
a third of a regular average working person is it's still a third, but it's a bigger chunk.
Yes.
A bigger realistic chunk.
Well,
than
it's depended on. It's
exactly.
It's more dependent on.
When you have so much excess.
Yes.
You know what I mean? It's like, I don't know, you weigh 500 pounds and you lose 50. I mean, it's something, but it's
Yeah.
in the grand scheme of
We
things,
still got a long way to go.
It's a small portion. But if you weigh 200 pounds and you lose 50, I mean, it's a big deal.
Yeah. Yeah.
I get that. That's a concept that I think is misunderstood about trust, and so that's why we have the seminars. We talk about them. We talk about wills and we talk about trust. Some people feel like a will is all they can do. They'll say, "I'd like to do a will," and if I say, "Would you like to talk about other options?" they seem surprised that there are other options. I thought a will is all we could do, and it's not.
Well, we may have someone who wants to chime in with us this morning.
Good. I need a sip
Hey,
of coffee.
good morning. You're on WDXE with us.
Yes, he may not want to cover this today, but I would be interested in long term. Let's say you have property and you want to put it in a trust, and when you die, the CPA enters the thing, and they want to go back and check on, say, the capital gains. And do they have to have the documentation from tax records? Because some lady called into a CPA the other day on a show, and she got into this. Even though rarely are you audited except every 3 years, if you have a house for 20 years and then you decide to sell it and then you're kind of panicky about capital gains and you're not of the age, and that's all the way up, the implication was if they suspect fraud or say they suspect fraud, there's no rule as to how far you can go back, so it could slow down the process. I would be interested to know if that's different in a trust transferring property versus just an individual, or it may be the same. And then later, I wish he would go back and cover anything that's outside a will. I've run into a lot of situations where people from other states or something have gotten things outside a will. Another example is a lady went to work and said, "I can't believe my ex left me some money." And somebody said, "Well, I thought that y'all left on bad terms." She says, "Well, he didn't change it. I don't know if it was insurance, annuity, or what. He didn't change the name when
All
they
right.
got a divorce and he remarried, and so she got the money, and it was outside the will."
All right. We'll see if we can talk about that. Okay. All right. She hung up quick.
All right. First of all, I mean, there's so much in that statement.
There was a lot in there. So,
and I can't even remember most of it. But this business about CPA getting involved after death, I mean, that's sort of a non-issue.
yeah.
If you have a trust, and I'm just going to limit it to trust, because if it's not in a trust, then maybe all that is true. because it's in probate court, and so I doubt a CPA would be involved, but the court would be involved because that's what a will does. It puts you into probate, and they supervise the distribution of what the will says to do. Now, let's just talk about a trust. When you put in trust, you take care of all that in the trust now. Where it goes, under what conditions it goes, and you can spell it all out. So I don't know why. Why you would need a CPA after death, other than, and you wouldn't, I don't know why you would need a CPA, but other than just you have to do a general accounting. When somebody passes away, even in probate court or a trust, you sort of have to gather all they owe and do an inventory.
Yeah.
Because you got to know what their all is. Because if you're saying I got 3 kids and they each get a third, I mean, we need to know what they're getting a third of, right? So we sort of have to do a general inventory. Now, anybody can do that. I guess if you have a pretty complicated estate, and CPA might be, if you got a lot of negotiable instruments out there that, like I say, change value over time. But that'd be the extent of it. I mean, there's no capital gains tax that I'm aware of after death. Capital gains come into play at a sale.
Yeah.
That creates a gain. Again, there's no tax until there's a gain, and there's no tax until there's a realized gain.
Right.
I think that was what I intended to answer, because after that it kind of got off on.
Yeah.
Oh, I can't even remember. But
she was talking about something that wasn't covered in a will.
Yeah, that's where I was going to go.
Outside of a will or something like that.
There was some other stuff she mentioned after that part, but then she talked about if property outside a will.
Yeah.
Now, I think what she described it was outside, like a spouse's will or something.
Right.
And she said the example she used was somebody said, hey, my ex left me some money.
Which would have been in a will.
So let's talk about that. Yeah, it would have had to been spelled out, because if you don't have a will and the laws of intestate succession take over, they do not include ex-spouses.
Yeah.
It includes descendants, right?
Yes.
So there would have had to been a will. Now, here's how that can happen. If you have a will and you say, I leave, typical reciprocal wills with husband and wife will say, I leave everything to my spouse. However, if they predecease me, then it goes a third each to my 3 children.
Right.
Let's just keep it simple.
Right.
So if you're the first to die of a couple, first death, then it's just simply all goes to the spouse, and that's the end of it, right?
Right.
And then at the second death of that spouse, the same clause fails because the first death took the first choice away. You don't have a surviving spouse, so now it's going to go to the children.
Right.
So if you suppose you say, I leave it to my spouse.
Mm-hmm.
Now, you write the will and you leave it to your spouse. 5 years later, you get divorced.
Yep.
2 years after that, you get remarried.
Yep.
Let me ask you a question. Do you or do you not have a spouse?
If you got remarried, you have a spouse.
Okay. Let's just approach it fundamentally, right?
Yeah.
Now, if you have a spouse, and you use the word spouse in your will, who is it referred to if you take this will out that you wrote 7 years ago and it says I leave everything to my spouse and if they predecease me? Now, who do you think that applies to?
Well, in my judgment, it would be to his new wife, but no.
Well,
but the will was, when it was written, it was to his current wife.
That's exactly right. Now we have an ambiguity.
So now we got a confusion is what we got.
We got an ambiguity. Now, when you have obviously he meant the first wife. Mm-hmm. Didn't change the will after he got married, got a new spouse, but use the word spouse, right?
Yes.
And spouse is a legal term, right?
Yes.
So how's the court going to know, because the person is deceased, because it's a will, they're deceased. Yeah. They have to go by the plain meaning of the document. They can't substitute their judgment for the deceased because they don't know which one he meant.
Yeah.
And so now you have property going to the new spouse that you meant to go to the old spouse. Now, the way it might happen with what the caller said is you might say, I leave property to Mary.
Yes.
Jane Doe.
Yeah, Jane Doe.
Which is your spouse at the time.
Yes. Okay.
And you get divorced, you get remarried, and you don't change the will.
Yeah.
Say, I leave her $20,000.
Yeah.
Well, now she's just not a spouse, she's just a beneficiary by name.
Yeah.
And if that's not changed, that's going there. I have seen that happen. Actually, there was a case some years ago. Actually, I wasn't even doing estate planning at the time. I was more doing some of the criminal work I did. But there was something that came up, and had a couple that about 20 years ago, or 20 years prior to this going on, they just decided, they're married, but they just sort of decided to walk away. Never went through the divorce. Okay. Now, when you have a statutory marriage, there's only two ways to end a statutory marriage. One is
Yeah.
by death, and the other is by a statutory divorce.
Yeah.
You can't just say, okay, let's call it quits and walk away. You're still married. If you're married by law, you got to be divorced by law. It's a statutory divorce is a remedy for a statutory marriage. So
Yeah.
they did, and they weren't. They just said, you know what, let's just part friends. They walk away. They would live in different places. Well, the husband passed away 20 years later, and he had this will that said exactly what we talked about. So there was some controversy that caused the will to be brought up and brought into court.
Right.
And so guess who comes out of the woodwork when it turns out there's property to be left, okay?
Yeah.
And it was, if I remember right, it was difficult, if we even could, defeat the rights of that spouse. They were firm. And the family was in arms, like, obviously. It's just absolutely obvious that he did not mean for her to get anything. They walked away from each other 20 years ago.
Yeah.
And my response is, I agree entirely. I hear you. I get it. The problem is, we're talking about legal proceedings. The legal proceedings are that he left it to her and never changed it.
Yeah.
Now, why didn't he change it? I don't know. He either forgot or didn't want to go to the trouble of it, because it's a little more difficult to change a will than it is a trust. If you have a trust and you want to do that, it's an easy thing to change.
Yeah.
And second of all, if you have a trust, I'll help you with the wording so those things don't happen.
Yeah.
I mean, I know how to put the wording in there. We deal with a class of people. We make sure that if we have a spouse, we're dealing with the spouse that is at the time of this writing.
Current,
stuff
yeah.
like that. You can say, I leave it to my spouse that I'm married to at the time of this writing, which is 20 years ago.
Yeah.
You know, and if that's the one you want, then but if you get married, those are one of the life changes that should prompt you to modify certain things.
Yeah.
Not just a will, but what about beneficiary-driven instruments, life insurance,
Yeah.
annuities? I think that was part of what they brought up. Suppose you name a person a beneficiary of a life insurance policy.
Right.
Yeah, that's a $300,000 policy, right?
Yeah.
Term life.
Yeah.
And you never change it, and then you pass away.
Yeah.
Let me ask you a question. Who do you think the insurance company is going to pay the $300,000 to?
Whoever's on the document.
I mean, it's a contract, right?
Yeah.
They are contractually bound to pay the beneficiary.
Yeah, that's
and you
what's
call them
gonna
up and say, look, he didn't mean that, because they're going to say, look, lady, I'm sorry, but we have an obligation to pay the beneficiary, and that's what we're going to do.
Yeah.
So you talk about a bad result. So, when you have things like that, you have to, I mean, it's not a daily thing, but I think big life changes are things that should bring that to your thought process. Divorce, new family members, maybe a child adult child getting married, winning the lottery, your financial situation getting better or worse, things like that should prompt you to keep up with this stuff. And you have to, because once you pass away, the language in the instrument is what's going to control.
Wow. Yeah.
Now, I can help word the language so that we end up with the intended meaning. So when people hear that, they don't understand what's going on, what's happening, how is this happening? They're not married and they're getting money out of this. It's probably more the exception than the rule that happens, because most wills are written by attorneys, and I'd venture to say any attorney that basically knows what they're doing knows how to word it, or would advise that client certain things.
Sure.
That, hey, this could be
Sure.
done this way. There's a lot of things like that need to be thought through.
Yeah.
A classic thing I see that needs to be thought through like that is guardianship of minor children.
Oh, wow,
We
yeah.
can nominate guardianship for minor children. And a lot of times people will say, I'll use myself and my wife for an example. Somebody say, I want to, if anything happens to me or my wife, I want Stan and Tammy Pierchoski to be the guardians. Okay.
Yes.
So we're naming a couple.
Yes.
Now, suppose they really want my wife, because she's real good with kids and she's a loving person, Me, not so much. Well, you know what I mean. Or let's just say I'm not so much.
Yes.
And that's kind of what they really had in mind. But what happens if this happens, guardianship vests with us,
Yeah.
then my wife is the first one to pass away.
Yeah.
Now, the question is, did they really want me to be the guardian? And let's say I'm not the best father figure in the world.
Oh, yeah.
I actually am, but let's just say we're not.
Yeah. Yeah,
But
you are.
But so that may not be. So when you name couples for guardian, we want to investigate and say, are we really okay with both, or are we really just interested in one? Because just because they're married doesn't mean we can't appoint them. So if you're okay with both, we can say Stan and Tammy, or the survivor thereof, which means we're good with whoever's doing it. acting jointly or other survivor thereof.
Yeah.
But if you want just Tammy, they might say, Tammy Pierchoski serving alone.
Yeah.
So if she passes away, the guardianship doesn't automatically vest with me or the spouse. Or somebody else that she would marry that you don't know yet because it's a future spouse and you don't know if they make a good guardian or not.
That's interesting and a tough question.
Yeah, those are things we need to think through and make sure because in guardianship, that stuff changes.
Yeah. I think I say something similar to this just about every time we talk, and that is how that a lot of us out there put this kind of stuff off, making these kind of choices, decisions, and preparations for the future and our future well-being and those that are behind us. It's so easy to put off.
It is.
And it's one of those things that no matter what age you are, you need to consider, consult, you've got a resource there with you and your seminars to study up and see what fits you and fits your circumstance. And I've just been impressed with the idea of, okay, these are some things that need to be handled, and I don't need to put them off.
Right. Now, this guardianship, as long as I'm on the topic, I want to bring that up. I think that is one of those ones I probably would have brought up a little while ago when you said, what do we get misinformation or it's mostly procrastinated. I think this is a heavily overlooked area because of misinformation.
Yeah.
The misinformation is a lot of people say, well, we've got an arrangement. If anything happens to me or my wife, Aunt Gertrude's going to take care of the kids.
Yeah.
Now, that is not legal authority. I mean, Aunt Gertrude may take care of them, and she may want to take care of them, but that is not the legal authority to do it.
Right.
The way we deal with guardianship, and you really should name it, because if you ask yourself this, if you and your wife are out on date night, and if you don't do that, I advise you probably should keep your sanity, right?
Yes.
If you're out on date night and you don't make it home that night, what's going to happen to your minor children? I mean, that's a thought that ought to wake you up in the middle of the night.
It's a terrible thought, but it's possible.
Yeah. So we can nominate guardians. Now, when you do guardianship in court, all guardianship ends up with a court order.
Yeah.
In other words, you can say, all right, I'm going to name these people as guardians, but that's still not the court order naming them that. There is a statute that deals with the appointment of guardians if the parents are gone, and it has a lot of things. There's a whole laundry list of things the court is supposed to listen to and put weight on.
Right.
One of the things at the very top is that they're supposed to put great weight on if the parents had nominated anybody as a guardian during life. They're supposed to put a heavy weight on that. And that's how we hedge our bet to get the order for those folks, because the court's going to take this approach. And this is what the statute's designed to inform the court of. If the parents are of sound mind and during life they pick somebody, they must have given that some thought. It's somebody they trust, somebody that they think will raise their children in their ways. Like maybe you homeschool your children and you appoint somebody that will continue doing that, or your religious beliefs. Economics. I mean, there's a whole bunch of stuff that you would consider when you choose people. And so the court is instructed by the statute that if somebody has done that during life, we're to put great weight on that, because that was not just a willy-nilly decision that they made to fill out these documentations where appointing guardian. Okay. So that's how we pretty much make sure that's how it ends up. Because if somebody else comes in and says, well, I think I ought to be the guardian, now it's a matter of proof before the court. Now that's a pretty tough burden to carry, because you have to show that you're a more proper person than the people that the parents named, which they did during life, which they would have given, sound thought to. So it's interesting because and the situation is ripe for abuse, because if you are parents in your 30s or 40s and you have some minor children and you're a prudent parent, you probably have pretty big life insurance policy, thinking if something happens to me, I want to make sure my family has the wherewithal to get by. I mean, parents not there, but the next best thing is a financial substitute, right? To fill in the finances that person does. So that attracts people to be guardianship, because a life insurance policy comes with it. And I hate to point out people's bad nature, but it's there. Right. There's no denying it. So that's why other people may want to throw their hat in the ring. Now, in guardianship, there's another thing you can do when you appoint guardianship, is you can also discreetly make sure that a certain person isn't the guardian. Yeah. You can voice your concern that I want it to be my brother, but I absolutely, positively do not want it to be his wife. Yeah. Now that is, there's, again, court's going to put heavy weight on that, because that's what your wishes are. Now, if you just have minor kids and you just pass away, do we know the parents' wishes for who? I mean, we know the parents have children. We know the parents probably love the children. We know the parents would have raised them had they not been something happened in a simultaneous accident or something. But what do we really know what their wishes were for somebody else? Thus, going into state's custody, thus being there until the court can investigate who all. Now the court's saying, okay, what, are there any family members that want to throw their hat in the ring?
Yeah.
And now the court's going to determine, but now they're going to hear everybody's argument from scratch.
Yeah.
And so it's a much better thing to do. This is heavily procrastinated, in my opinion, is this guardianship issue. Let's name them now. Now, I will admit that if you have young children, like my daughter that just visited for a week has a 3-year-old and a 1-year-old.
Yeah.
And they have named guardians. Now, before those children reach age 18, they're probably going to change the. As a matter of fact, they live in Miami, okay?
Yeah.
And they had super good friends. There was only person my daughter said I would trust to leave my kids with while we go out to dinner. You know, his best friend. Well, they took a job, and I think they went somewhere in Wisconsin or something. You know, they left. It was broke everybody's heart down there because they were such good friends. But you know, now she's already had to change her guardianship once because her best choice is no longer. Now it's more of a long-term choice. I mean, she still would be interested in that person if, you know, for long term. But I'm just saying that till the children reach the age of majority, which is 18, you're going to change it. Circumstances in that area, people being guardians are going to. So let's say you name your parents. Well, you know, after 10 or 15 years, I mean, if somebody wants to name me as a guardian, I'd say I'll be more than happy to do it. But keep in mind, I am of a limited time. I mean, I'm you know, older than the average parent with minor children.
Yes.
And so I'll be glad to do it, but my time is limited. So you might want to give it some thought or make more of a backup, but just in case person. Yeah. That sort of thing. But again, needs to be thought through, and it's not as simple as you think, you know.
No. Well, the thought crossed my mind, you know, we talk about wills and trust. How is it addressed? What documents are there that address guardianship?
Well, we have independent documents. We call them the Children's Protection Program. They're independent, but you can put it in a will. Okay. And when you do guardianship, you know, it also generates power of attorney, because guardianship is not legal custody. I mean, you're the person in control of this person. But let me back it up. It is legal custody, but it's not parental rights. Okay. Because only the parents have parental rights. But it's the next best thing. And so when we do guardianship, we generate a power of attorney, general durable power of attorney for a minor, and the power of attorney for health care for a minor. So these people have the authority to make those decisions as well, because we're not dealing with any incapacity, but a minor can't make those decisions. Yes. And so the only way the guardian can is we have to give them that specific power. Wow. Because when you get to court, I don't want to get too heavy in this, when you get to court, when you deal about guardianship, you have a financial guardian, you can have a property guardian, and those are the guardians that's what they deal with for children. And we see that sometimes when we have a will or a trust and you're leaving property to your kids, but your kids are minors. Yeah. We have to address the fact, if something happens to you and one or some of these children are still under the age of 18, they can't get their inheritance. They can inherit, they just can't get it until they're 18 years old. Right. And that's our Uniform Gift to Minors Act. So we have to leave it in charge of somebody, and that would be a financial guardian, or kind of like a trustee over it. Only it goes by a different name, and it's just somebody that would hold that property until it's time to give it to them. Now, in a trust or a will, you can actually say when they get it. Now, in my opinion, I don't think I'd leave an inheritance to an 18-year-old kid, because I don't think, in this day and age, I don't think they can handle it. Yeah. And it's very popular that my clients don't, they say in there, if this goes to a minor, the parent can control it, or whoever's controlling it, they don't get it until they're 25. Yeah. Because they want the person to be financially responsible. And at 18, I don't know. I mean, some are. I'm not saying all of them aren't. Right. Some are, but I think
there's always exceptions.
A lot of them aren't. And I say that, for my own circumstances. I had a child that just, became financially responsible, but not until about 25 or 26, in my opinion. So now extremely financially, but it just took a little while for the light to go off. Yeah. It was whatever.
It took a long time for the light to go off with me.
I mean, I get it. But these are the what ifs. You don't know. Because if you got a child that's 5 years old, I mean, you don't know what kind of child he's going to be, what his personality is going to be, what his calling is going to be. I hate to say it this way, but you don't know if he's going to be a criminal. You don't
Oh,
know
yeah,
if he's
you
going
don't
to be
know.
upstanding citizen. You don't know. I mean, the hopes are always there, and we want to bring them up that way. But so there's not a whole lot of. I mean, you don't want to nail it down too tight when they're so young. You know, as
Yeah.
they get older and you start seeing the things they're doing that are great, and sometimes you see the things they're doing that are not so great.
Yeah.
And I don't mean not necessarily criminal activity. You know, you always, everybody knows a family where they got a child, and I'll say it's a daughter,
Yeah.
just because it seems to be mostly, it can be the son, but
Yeah.
and they had girlfriends and maybe a wife or two, and they always just seem to pick the worst people to marry. You know what I'm talking about? Which great, and now that generates a lot of concern with the parent,
Yeah.
right? It's
Yeah.
like, my daughter's sweet and she's wonderful, but she's always attracted to the same kind of man that this, that, and the other thing.
Okay.
Or,
Okay.
Just, and negative or whatever.
Okay.
And so now this person is developing this personality, and now it comes to mind things I want to control and protect if I'm going to leave her an inheritance.
Yeah.
I just got done drafting something. As a matter of fact, I think it was the day before yesterday, where the specifics were I'm going to leave this to this person, but if they're still married, then they name the person I named that person. Then I want it to go to the kids. I
Yeah.
don't want them to have it because they know that their spouse is going to invade it somehow. I mean, I can put in all kind of protections, but they said I don't care what kind of protections. He'll weasel his way into it somehow. He's just that kind of person. So we're going to give it to the children. But if not, then it goes to my daughter.
Yeah.
And I was talking about the daughter.
Yeah.
And it didn't want to leave the daughter if she was married to this person because even though they trust the daughter, they know she was highly influential by this guy, spouse. And think about it. The daughter's in a rock and a hard spot. She wants to keep her marriage sound, but she also wants to do what mom wants to. Her parents want to
Yeah.
do, and so she's in a rock and a hard spot. But so they just said, if she's married to this person, she doesn't get it. It goes passes her and goes to the kids.
Goes to the kids. Interesting.
So and you can do that. You can do that in a trust. I mean, you can do
You can
terms
do
and conditions.
It's almost endless to the possibilities of what you could do.
You've heard me say this before. When you're writing a trust, you are writing the rule book.
Yeah.
And the great thing about that is, if you're writing the rule book, the courts say, if there's no illegal purpose in here, we will enforce the rule book.
Yes.
And I've seen court cases where they talk about these bizarre terms and conditions, and they uphold them. Yeah. And their logic is, they have when the legislature said the trustor, that's the person who writes the trust, the trustor's intent is paramount. That's a strong word. And they say, we will not disturb the trustor's intent absent compelling evidence to do so. In other words, there's got to be a really strong reason why somebody's passed away.
Yes.
We're reading the trust, what they want to do. You got to come into court with something extremely compelling before we're going to disturb what this was. Just not liking it, doesn't cut it.
Yeah.
If you come in and say, well, it's just not fair. I didn't get a fair share. That's not going to get it.
Won't work.
That's right. I mean, and I don't even know what that compelling evidence would be. I mean, I could come up with a bizarre example, but it's a tough burden of proof.
Yeah.
And what they're saying is, if you are putting together this trust when you're of sound mind, who are we to disturb it? It has to be what you want.
Yeah.
Or you wouldn't have done it.
Yeah. Exactly.
The common sense of that is a superpower. It makes just too
Yeah.
much sense. So their logic is not, they're not trying to be for that person or against that person. They're saying if a person sits down and writes a trust, maybe sits down with an attorney, expresses their concerns, and this is what they come up with to be the solution to the problem that they have, then it's an agreement.
Yeah.
We cannot impair the obligation of contracts.
We don't have a lot of time left, but I was going to ask you, it just crossed my mind, what do you feel like is the most difficult decision for people to make as far as what to do with some things? After you've had the experience of meeting with a lot of people and making decisions on how they want things to fall out, are there ever those that we just don't know what we want to do with this?
Yeah, there is. Sometimes there's people that don't have people to leave to, like don't have children.
Yeah.
And another one is when there's few people to leave it to.
Yeah.
And the one or two people you can leave it to do have some of these problems.
Yeah.
I mean, here's a classic one, and I see this a lot. Now, and it really, the people leaving the property struggle. You got somebody in the family that you want to leave it to, but they're just the ultimate deadbeat. I mean, lack of a better word.
Lack of a better word.
They're living in somebody else's house. They're not paying rent. They don't pay for food. They won't leave. They won't get a job. Fill in the blank here. It's just, you know, you have done, and you and the family have done everything to encourage them to be financially responsible, be a contributing citizen, to get a job, or, you know, carry your weight, just all the normal things that people do, right?
Yeah.
And it's just not successful. And finally, you know, I hear people come to the conclusion that it's never going to change.
Yeah.
It's just never going to change.
Right.
Now, I'd say never say never, but you know how that goes. I mean, something could happen. I'd always be hopeful, but do I want to leave my inheritance to this person because it's just
going to be wasted away?
Well, it just fuels that thought process that I'm not in agreement with.
Yeah.
And so it's not necessarily wasted away. I'm sure they'll use it for.
Yeah.
But you know, do you want to foster responsibility?
Interesting.
So, you know, we can fix that. We can put it in trust and have the trustee just not give it to them unless they have accomplished certain goals. I mean, if you're not gainfully employed, then we're not going to fill the gap for you.
Yeah. So that was interesting. I was thinking about that. Of course, if you have some circumstances where you would have to make some kind of tough decisions, but having someone like you to consult with who's got some experiences with this, there are ways to handle almost anything.
Well, if somebody says to me, I don't know what to do about this situation, I can offer suggestions of what I've seen done, what I know can be done to deal with it. And then, you know, you certainly will pick the solution, but we can spitball on options and possibilities because they don't know what to do. And, but here's some options we can do. Some are kind of harsh.
Yeah.
Some not so much. But you know, you have to, because, you know, as a parent, you love the child. You know, it's kind of like scriptures. You know, you love the sinner, not the sin, right?
Yeah.
And so you love the child. You just don't love what he's doing or not doing or whatever this attitude or characteristic is.
Right.
But and again, you're probably always hopeful that it'll change. But again, sometimes when you have a bad habit and you leave somebody an inheritance, you can be the instrument of their destruction. Yeah. You're not doing them a favor if you do that. So
right.
So all right, so let's wrap it up and let me go back over the seminar that's coming up.
Right.
I don't know what's set for next year yet, but that calendar's going to be set pretty soon, and so we'll be. But you know, the first one would probably be somewhere in mid to late January. But the next one coming up is November the 2nd. November the 2nd is a Saturday, and our Saturday seminars, which we call Wills, Trust, in the Nursing Home, and that's what we talk about, are always at 10 o'clock in the morning. Now, this one is a little bit up north, but I don't know, 40 minutes up north to Franklin. And it's at a place called Suite 501. And now that's the physical address of that is 416 Mary Lindsay Polk Drive, Franklin, Tennessee, if you want to put it in your GPS. But call me at Pierchoski Estate Law, Pierchoski Elder Law at 931-363-7222 to RSVP or let us know that you want to come to that. Or go to my website, estateplanstand.com, and I think you can RSVP that way. Or you can just give me a call and talk about anything that you want to talk about, and we'll talk about it.
Sure, absolutely.
And my last minute is let me go over at the Star Theater, which is right next to my office on the square.
Yeah.
Next weekend, not this weekend, next weekend, we're doing the evening with Edgar Allan Poe. It's only one weekend. It's a Friday, Saturday at 7, and a Sunday matinee at 2. If you like those kind of literary stories, sometimes they're a little dark, but that's Edgar Allan Poe.
That's Edgar Allan Poe.
But I mean, they're very entertaining.
Yeah.
They're just not comedies.
Yeah.
Brick somebody into a brick wall is not exactly a laughing matter. But they're pretty cool, and the people they put a lot of work into it. Then in the second and third weekend of November, I think it's the weekend of November 8th and through the 16th. We're doing the one I'm directing, which is Grease with a twist. So we have all our cast is like 35 or 40 and above.
I think that's going to be a lot of fun.
All the leads anyway. We do have some young people in the ensemble, but all the leads are
That's
older
going to be a
folks.
lot of fun. I know y'all are going to have a good time with that.
So.
Yeah. On the square in Pulaski, Tennessee, Stan Pierchoski's office right there on the southeast corner of the square.
That's right.
And really next to the Star Theater. Not hard to find at all. Beautiful square, busy place. Stan Pierchoski, everybody. Estate Plan Stan is the website. That's the best way to get some more information right there. And, of course, the phone number 363-7222. Always good information, brother.
We'll be back here every Friday at 8 to 9 for Bulletproof Estate Plan.
All right. Take care.
You too.
See you next.
This is WDXE, W287AA, and W237FD Lawrenceburg. Broadcast services of Prospect Communications.